Hello, Internet! Welcome to episode 208 of the Assorted Calibers podcast. The Second Amendment podcast is a little bit for everyone. I'm Weer'd, and with me tonight is the very bestest hostess in the universe, Erin Paulette. How are you doing, Erin?
You spelled my name Palette. I don't like that.
I always
It's one L and an E at the end. You spelled it P-A-L-L-E. Well, a lot of people do P-A-L-L-E-T. You did it double T. But then, of course, despite being a native English speaker, you're barely English literate. So I don't even know why I'm disappointed.
I'm dyslexic. I've never been able to spell. I don't think it's going to learn correct. Double letters are the worst for me.
The thing is, I think this is the first time you've misspelled my name.
I think this time I was rewriting it because we'd done so many of the round tables, and so and most of the time I go, how the fuck does she spell her last name? And so I didn't
I'm your little pal, Palette.
You know what? That's the first time I've ever looked at it that way, and congratulations, Erin, you've won.
It's a pointless victory, but I'll take it nonetheless.
You have crushed me. You have driven before me. You can hear the lamentations of my women.
Oh, shut up. You love it.
I've been smiling the whole time I said that. Oh, boy. Well.
So, Weird, did you have a pleasant 4th of July?
I did not.
Or I'm sorry, but before the people get all uptight, did you have a pleasant Independence Day weekend?
Yes, I had no, not particularly. I mean, the weekend was actually quite good, but come Independence Day, it turned out like just plans didn't work out. Usually we have a few people over and kind of have some festivities, and it just we kind of haven't really done. We've only done low key stuff since like the lockdowns, and now it was one of those like, oh, there's going to be stuff going on and the town's having all the festivities. And then my wife was just kind of grumpy just from the word go. And then my daughter was slowly starting to feel a little bit more just logy and crappy. And finally, when we were sitting down for lunch, she's like got her head down on the table. I'm just like, oh, you're definitely sick. And she goes, yeah, I want a COVID test. I'm like, don't waste them. Like we just checked you with a thermometer. You're not running a fever. You just got like a stuffy nose and you're just feeling a little tired. You know, you don't have it. And my wife goes, look, we got like a bunch that are going to expire soon. So it really doesn't hurt anything and it'll make her feel better. I said, fine, go do the COVID thing. But you want to put a little money on it not being positive? And she just kind of rolled her eyes at me. Well, she should have taken that bet because my daughter has COVID. And I say, and the laugh that I have right after that is 100% appropriate. She literally has the sniffles. She has a stuffy nose, and that's it. She has been running around the house and happy-go-lucky, and behaving great. She had a great day today. So, guess what? She's gonna make a full recovery. She'll probably end up giving it to at least one of us. We'll see. My wife's was feeling a little crappy. She hasn't been sleeping well the last couple of days. So hopefully it's that. Knock on wood. It's not that. She's probably going to catch it too. I probably will too. I don't know. We'll see. We'll see what happens. You'll find out next week on the Assorted Calibers podcast. But yeah.
No, it's my understanding that your wife is a bit of a germaphobe.
She is. And she's a chemist and she works for a pharmaceutical company. So she's like, I know, but still. And so, yeah, she's a little uptight about, though she's been fine today about it. She was a little uptight yesterday, but yep, we're laying low. Thankfully, I just heard back from the summer camp she's supposed to be at right now, saying that we can get a refund. So at least we've got that because they're not going to let her in. So yeah, that was my 4th. Got to watch the fireworks and got to watch the parade. And the parade had an Oscar Mayer Wienermobile. That's literally the high point of my day. I don't think I've ever seen an actual Wienermobile in person, and I really enjoyed the hell out of it. I won't lie.
Well, we all know how you feel about big wieners.
I mean, it's a huge wiener. It's a huge wiener. All right.
Title of your sex tape.
Yes. How was your Independence Day, Erin?
It was pleasantly low key. Okay, everyone who knows me knows that I am not about crowds, and I don't mind fireworks so long as they don't go on late into the night when I'm trying to sleep. But, I don't like crowds, and this is Florida in the summer, and it's hot. Why would I want to go out in that? So I just stayed home, and I did some writing, and then I played City of Heroes with my patriotic character because that seemed like the thing to do. And fortunately, the dogs were kind of chill about it. We didn't have the truly annoying, the next cul-de-sac over, someone's firing a mortar over the lake, which is just really bad. Because, I mean, when people are firing off fireworks that are shaking the windows of the house in a suburb, that kind of makes me a bit twitchy. So
I'm
we
sure
didn't
it
have
damages
that.
the calm of the dogs quite severely.
Yeah. Plus, one of the things I like to point out is that Florida's often a fire hazard at this time of year. So, that's why the professional shows are done over lakes or the ocean or things like that. So, but yeah, it was pretty calm and it was chill, and I like that. So
Well,
I didn't do much of anything, and I was happy for it.
Well, good times. That is a boss of mine one time said when we were just kind of chilling out. Hey, how you doing? He says, I got nothing to do and all day to do it. And I've even turned it around too. I've got nothing to do and all day to do it, and I'm probably not going to get it all done. Oh, so speaking of nothing to do, we have got a show all set up for us already. So I think without any further ado, Erin,
Ado.
Yes. You very, very wisely requested last week that I reach out to Benjamin Blatt to talk to him about the current events, and just the logistics didn't quite line up. And I won't lie, I really wanted to do that round table. So it did not happen. But Erin, I heard you out, and you are a very, very wise person. And so I reached out to Benjamin Blatt to talk to him, and we're going to be hearing him twice. And the first interview that I have with him is going to be about the Bipartisan Safer Communities Act bill and what he thinks that means for America going forward. So I would like to welcome back to the Assorted Calibers podcast, by popular demand, firearms lawyer Benjamin Blatt. And a lot of people have been asking questions about two major events that have happened. One is the NYSRPA versus Bruen Supreme Court case, and the Bipartisan Safer Communities Act, and which was the bipartisan gun control-ish bill that was going through. And I thought I'd have you on first to talk about, well, we've talked on the show about essentially what's written down in this law, more or less. What are the broader implications? What is this Bipartisan Safer Community Act going to mean to gun owners in the United States over the next few years?
Well, for the most part, it is going to mean more red flag laws. Right now, about half the states, I think it is actually 25 states, have some form of a red flag law. Indiana, where I'm at in particular, has one of the worst and one of the oldest. But basically, the impact of the red flag laws are, in the end, that people who you may not know or may only have passing acquaintance with will have the ability to tell police that you may be a danger to yourself or others, and trigger a set of circumstances in which the police will go to a judge and get permission to seize your guns without you having committed a crime or having allegedly committed a crime, and put the burden of proof on you to convince the court that you are not a danger to yourself and that at some later date you may get your firearms back. Now, in theory, the way that the law is written, there is a due process structure built in, but the reality is that that due process is laughable. You know, in Indiana, for example, if the court finds that you were a danger to yourself based on the limited documentation the police are required to provide to the court, you have to wait basically half a year before you can even allege that it's time to get your guns back. And the Indiana State Supreme Court has ruled in a case that is the established case law here that the burden of proof is not only on you to prove that you're not a danger to yourself, but that you have to substantially prove that you have changed. In other words, with like a paid-for psychological exam, and the state may still rely on the initial seizure evidence that they use to determine that your current exam isn't relevant and that you're still a danger. So in other words, it's very difficult to get your guns back from the red flag in Indiana. And there's a danger to it in terms of, okay, there's a due process. Supposedly the judge is supposed to consider evidence, both before the seizure and then at a hearing where you're allowed to present your own evidence and essentially face your accuser. But we can see that that's not the reality of these things just from Florida, where in Florida, within the first year of enacting their red flag, there were something like 2,200 cases, and it was like 98% of the time the judge signed off on the initial red flag and then upheld their initial determination. Now, that is a statistically improbable number, that out of 2,200 cases, a mere few dozen would be found to have been justified in getting their firearms back under the red flag, and that the court would have gotten it right 98% of the time on minimal evidence. The implication then is that the courts are unwilling to go back on their initial decisions to seize the guns, and basically once your guns are seized, you're screwed. Now, you might get your firearms rights restored under your state's red flag law, but you'll probably never be able to afford the judicial process and the litigation costs to get the guns you lost back, which means essentially the state's going to be taking guns whenever they want, with whatever they can justify, and the federal government will be providing them the funds to do so. That's the red flag implication from the bipartisan bill. The other gun control implication is for people 21 and under, the whole juvenile record issue. Basically, the way that's going to work is that if you are a young adult who wants to purchase a firearm, you are going to face enhanced wait times for your background checks, and they are going to dig deeper into your background than they would for someone who is in their mid-20s, for example. They are going to contact your local police agencies. They're going to look at your juvenile record, which means effectively the juvenile records can no longer be considered sealed anywhere. And the states that do still consider juvenile records to be very thoroughly sealed will only make it worse for those people's gun rights, because essentially they'll create roadblocks to passing the background check. So basically it's going to be hard for young adults to buy guns without a long and arduous process, even in states where the only requirement otherwise is you go in and you pass your NICS check. Moreover, there's nothing in the bill that would prohibit those records from being kept on file and used against that person at a future date. So if, for instance, someone had a juvenile record incident that for some reason would prohibit them from buying a gun until they were 22, or that, brought into question to the point where they had to wait on delay before the FBI determined, this isn't really a big deal, that record would continue to haunt them well into adulthood, because it would continue to be in the FBI database for something to be reviewed. And, for someone in my age, in middle age, and for someone like the host of this show, we're well past that point. We don't have to worry about those records. It doesn't really affect us. But anyone who's ever had a juvenile record will have some level of effect. And as the years go by, more and more adults will continue to be haunted by the things they did as teenagers, even if they aren't criminal acts that would otherwise prohibit them from possessing firearms. So those are the two big implications of the bipartisan bill, is more stress on the system as far as background checks go, more delays, and as people age into the system, those delays will continue to increase, and then more federal encouragement for red flag laws that are designed to just strip people of their guns and gun rights without anything in the way of what we would consider proper due process.
So one legal question I had specifically, and you might know more about this, especially since you go and reference Florida's red flag law as well, is in the law, it specifically states that it requires something to be done if it is done in error for actually for if people who are abusing the system, there should be penalties. Are there any such penalties right now in the various states that have red flag laws?
I can't think of a single state that has a penalty. And as far as any penalties would go, part of the risk and the threat of red flags is that to show that someone might have encouraged a penalty, the court would have to convince itself that it got the first call wrong. So the judge who basically made the call to take the guns in the first place is the same judge making the call to keep the guns from the person. And if in fact there is someone who did something wrong, which is the most likely circumstance, is that this gets heavily abused in domestic cases. But that same judge would then have to not only be convinced by the weight of evidence, but mentally convince themselves that they did something wrong, that they were taken by this false evidence, which is an unlikely thing. You know, one of the reasons that things like the Innocence Project, for all of its many, many flaws, exists is that there are, in fact, people on death row or in prison for life who should not be there. And sometimes that's from weight of the evidence. Sometimes it's from evidence withheld. But many times it's from judges who made the wrong call on evidence because they were unwilling to tell themselves or convince themselves that, in fact, it was the wrong call, even when it was evident to those around them. And as applied to red flag, I think the end result is going to be much like perjury laws in this country, where if you lie under oath in a court proceeding, there is a penalty, a criminal penalty that should apply. It's called perjury. However, as a matter of actual application, almost no one is charged with perjury anymore. And of those charged, almost no one is convicted because the courts simply don't want to deal with having to address this person actually lied under oath and maybe the finder of fact believed them to an extent. So I don't see, even if there are penalties enacted, though that penalty risk being really effective at preventing false red flaggings. Worse, from my perspective, and hopefully from most people's perspective, the red flag concept in general is a deprivation of due process rights established under what's known as the Baker Act, which people popularly know as the 72-hour mental health hold. That's the law in almost every state, if not every state, thanks to federal actions. But the short form of it is if you are a risk to yourself or others, and someone tells the police this, the police have the option of taking you and putting you in a mental health facility for a 72-hour examination by a mental health professional, who then reports to the court as to whether or not further hold is appropriate, or if in fact you aren't a threat to yourself and can be released. There is a very good process built into that in terms of due process. It can be abused, but there is also plenty of options to get people in terms of addressing the abuse in court. For example, the first case I ever handled as a licensed attorney was a Baker Act case where someone had been sent to a 72-hour hold. And I determined it was inappropriate, and I had my client out of that hold in the first 24 hours because the court agreed with me after I filed for an emergency hearing. You don't have any of those options under the red flag laws. There are no emergency hearings. There is no shortcutting the process, and there is no examination as to whether or not you are in fact a threat to yourself or others by a mental health professional when you use the red flag law. But the effect is still the same. If after the 72 hours you're determined not to be a threat to yourself or others, you go home and you still have your guns. If after that 72 hours the mental health professional tells the court that no, this person is a threat to themselves or others, and we ask that they be held further, once the court issues that order to hold a person further in a mental health hold, you lose your federal firearm rights. And in most states, that also triggers a loss of firearm rights just as a double down, because you've been adjudicated to have a mental health issue. You no longer have your firearm rights, and then your firearms are seized under the Baker Act after you've had your due process, after you've been in court. The effect is the same in terms of preventing public risk.
Yes, and furthermore, we all note there was even the websites that were up ages ago that had an AR-15 with a webcam on it, is that guns don't do anything without input, but yet people do all sorts of things with all sorts of input, and we're resourceful and we'll come up with ways of doing horrible things. And so somebody's at danger to themselves or other people, just taking the guns away and leaving the person unsupervised is not going to help anything. And in the instances of someone who is either in mental crisis and is at risk of harming themselves, or they are stalking or threatening another person, such red flag intervention may in fact upset them to the point of forcing their hand into action. And
sure,
so I've always had disdain for that.
Yes, and basically what it boils down to is this. With the Baker Act, with the 72-hour mental health hold, the police have to show that someone is a genuine threat to themselves or others. Now, it could be as simple as a report of someone saying they're going to kill themselves. But the police then have to bring that person to a mental health facility, and the mental health facility has to do an actual examination of the person and make a report to the court before the court makes their legal determination. With the red flag law, basically the state says, oh, we get to shortcut this. We don't have to make that determination. We don't have to provide mental health resources or assistance. We can just take the guns and pat ourselves on the back because it makes us feel good, even though it doesn't reduce the threat the person may present to themselves or others. And even though it basically robs them of their rights and due process to not only keep their firearm rights, but also to get the mental health that the Baker Act contemplates. Indiana is a great example of the pitfalls of this in terms of the actual case. The reason Indiana's red flag law is one of the oldest in the country is there was a case where a guy went nuts down in Indianapolis and shot up some things and killed a state trooper. And the Indiana state legislature immediately responded by naming the red flag law after the state trooper and getting it passed through in almost record time. But the actual incident itself had every single hallmark of, oh, this should be a Baker Act, where the man was reported before he went off his rocker and started shooting things up to be someone in need of mental health help. He should have been taken to a facility. But the police decided not to do that because, among other things, it would have meant paperwork. So the Indiana response to the whole incident was, well, we'll institute a red flag law so we don't have to worry about Baker Acting anyone. But it doesn't fix anything. And all it does is, in exchange for the police not doing as much paperwork, deprive citizens of due process rights. And now half the country, essentially, it might not be 25 states, but certainly the most populous states in the country have these red flag laws, so certainly half the population, not more, fall under red flag laws. And we're in a position where those people, the politicians say, oh, we're doing a great job. We've got these red flag laws. We can take guns from people who are dangerous. But what they're not saying is that, in fact, what they're doing is depriving these people of their due process rights, because if they are a danger, if there's any reason to believe they're a danger to themselves or others, that same level of threat should trigger the Baker Act and send them to actually get help. But that help costs the state money, and it costs the police time on reporting, because it is a more detailed police report to explain why you sent someone for a Baker Act hold than it is to say we got a report from someone's neighbor's ex-girlfriend that they might be a threat to themselves. So we went to the judge who's on duty and said, hey, we'd like you to sign this red flag order.
Yeah, well, there's crazy stuff ahead. So, of course, obviously this law does not enact red flag laws on a national level. So all of you in states that are fortunate enough not to have red flag laws on the books, we need to fight.
It doesn't enact red flag laws on a federal level, but, it's worth noting it's something that Nick Rekieta has talked about. One of the states, the less populated states up north, I think it might have been South Dakota, had sued the government because when they passed the speed limit acts, basically saying, if you want this state funding for transportation, you have to have speed limits of 55 miles per hour. And this state said, no, we don't want to do that. And you are basically depriving us of too much money, by withholding this money from our budget in exchange for passing a law that's not relevant to our state. And at the time, the Supreme Court found that amount from their budget, which was something like 20% of the entire state's budget, was not a coercive taking. That basically the federal government could withhold 20% of the state's budget to make them enact a law that was supposedly voluntary. So it's not a federal red flag law, but the effect of it is that every state's going to have red flag laws because it's basically a budget contingent thing. If states want to keep their budgets, they've got to put the red flags into place.
Well, then what do you think is the best solution moving forward?
The best solution would be the Supreme Court finding that red flag laws, as a matter of any policy, violate the due process rights of the Baker Act, because they both stem from the same triggering functions. And basically, all they do is create an either-or option for the state to provide less due process to citizens. But that's a lawsuit that I'm not sure would succeed. And I don't know that even the FPC would be able to move forward on that, because you would have to argue that there is some innate rights built into the Baker Act that are being deprived by not utilizing it.
Well, that's certainly an interesting thought experiment, and we will see what happens moving forward. Thank you so much, Benjamin Blatt, for joining us on the show.
Yeah, not a problem.
Now, before we discuss our take on this, Sean Sorrentino sat down with Clayton Cramer to get his take on the very same bill.
Clayton Cramer is an American historian, author, gun enthusiast, and software engineer. He played an important early role in documenting errors in the book Arming America by Michael Belial, a book that was later proven to be based on fraudulent research. His work has informed Supreme Court decisions, including D.C. v. Heller and McDonald v. Chicago. Welcome to the show, Clayton.
Thank you for having me on.
Clayton, Congress passed and the President has signed the misleadingly named Bipartisan Safer Communities Act, a gun control bill that includes federal grants to states encouraging them to pass so-called red flag laws that permit local governments to identify people they believe are dangerous and seize their firearms. So what is a red flag law?
Red flag laws are also known as extreme risk protection orders. And what happens is that someone who thinks that you may be a danger to others because they think you're about to go off the deep end and start killing people, and go to a court and request an order that you be at least temporarily disarmed until they can make sure you're not really a real danger or not. And of course, the thing that's scary about this is that how sure are you you're going to get your guns back? The other problem is that most of these sort of protective orders that are being issued in the small number of states that have these laws have a provision called an ex parte hearing, meaning that you may not even know that you're about to be deprived of your gun rights. But that's supposed to be a temporary matter. Like most ex parte cases involving divorce, where there's a protection order being issued by a court, this is a temporary thing until they have a final decision some weeks later about whether this protection order needs to be made permanent or not.
In your recent blog post, you took issue with an article at Red State that said, people assume that language to mean that a person will have the right to know the evidence against them, to confront their accuser, adverse witnesses, etc., before they're stripped of their rights. That is not what the language means. A court can still decide to have an ex parte hearing, and the quantity and types of evidence the respondent, which is the civil version of a defendant, can present. I tried to read the bill. I had a lot of trouble understanding it, but you say the bill quite clearly says that people will have due process. Can you explain?
On page 33, it explains that that they will provide funding to states that have these extreme risk protection order programs, but they must include, quote, pre-deprivation and post-deprivation due process rights that prevent any violation or infringement of the Constitution of the United States, including but not limited to the Bill of Rights. They list a number of particular items that have to be present as part of due process. The right to be represented by counsel at no expense to the government, heightened evidentiary standards and proof, which mean not less than the protections afforded to a similarly situated litigant. Well, basically, they're saying in any similar sort of case, you have the same right to demand that the government provide the evidence that you are, in fact, a danger to others. And that means it cannot base this on hearsay, unreliable, vague, speculative evidence that is lacking foundation. And in effect, it's basically saying that the constitutional rights that would apply to you in any other sort of hearing apply to these sort of extreme protection orders. It isn't like they can just come in, say, oh, you're a danger to others, take away your guns, and that's the end of it. That can only be done on a temporary basis. Most states specify that these sort of ex parte hearings have to have a final decision within typically 2 or 3 weeks at most. Now, the thing that's very interesting to me is that this actually imposes due process requirements onto these states as a condition of them receiving federal funds. So in some way, I would say that this is actually one where the rhinos actually put one over on the Democrats, because right now the states do not have any of these sort of requirements imposed on them. So they will now have due process requirements. There's a number of protections here for gun owners who are being subject to these extreme risk protection orders. We actually gained something here. And in exchange, Democrats did not get any assault weapon bans, did not get any magazine bans. Democrats got practically nothing in exchange for a requirement that red flag laws, the states that have them, have to conform to the due process requirements that would apply to any other sort of hearing.
So it sounds very much like what you're saying is the requirements that are in the bill in order to get the money are much higher than the requirements that they would impose upon themselves had they decided to do this without our help.
Right.
So I've actually heard at least one person say that when you look at the gun bill, Democrats fell for a Republican trick. They didn't get anything they really wanted, but Republicans managed to sneak better federal due process rights past them. That's basically what you just said.
Yes, an awful lot of the gun rights organizations, the minor ones, not NRA, have been pretty upset about this bill, and I think some of it is they're actually just trying to raise money. I'm making a big issue of things that might, in fact, be a problem under rather unusual and unlikely conditions. For example, there's a lot of fuss been made about the fact that people between 18 and 21, if they go to buy a gun, they can be as much as a 10-day extra days of waiting for background check, while the FBI checks local police for if they have any records that might have been sealed by the person being a minor at the time of incidents. There's a case out of Texas a couple of days ago where a young man was arrested for making terroristic threats because he was threatening to do a mass murder at a school. He was 19. He had bought a couple of guns, and it turned out that he had actually been involuntarily committed to a mental hospital when he was 16. That's the sort of thing that did not show up with the background check when he went to buy guns. That's the reason for the additional waiting period, is they want to be able to look for people who've got these records that are sealed from when they were younger, involuntary mental hospital commitments or criminal records. So a lot of people do not realize is that in some states, even murder convictions get sealed when you turn 18. In California, some of the drug gangs rely primarily on minors to commit murders for them because the minors will have their records sealed when they turn 18. That will not follow them for the rest of their lives. I think that was a fairly reasonable thing to add in there, and I think we're not really giving that much up. I mean, for a small number of people between 18 and 21, there may be a little additional delay. We'll verify that they're not mentally ill or someone with a long criminal history that has just sort of disappeared when they turned 18. One of the things this bill includes a fair amount of funding for various mental health programs aimed at young people. I think this is rather important because an awful lot of the problems we've had with the school shootings over the last few years have involved young people with significant mental health problems. This guy in Texas that was arrested a few days ago had been given medications for his mental illness when he was in the hospital, but he has stopped taking his pills. This is actually a pretty common problem. People with serious mental health problems who stop taking their medications, of course, are a lot more likely to be a problem than the ones who keep taking their medicines. And that's one of the things a lot of people simply do not understand. They read that, oh, so-and-so have been taking an SSRI antidepressant. And yeah, that's true. An awful lot of people who commit these crimes have taken those, but they aren't necessarily currently taking them. They, in many cases, are people who need to be medicated but had stopped taking it. It's a pretty common problem. I had an older brother, Ron, who had a schizophrenic breakdown when he was in college. The rest of his life was basically spent living on the street or sometimes living with my mother. He was occasionally violent. He attacked complete strangers on the street. When he was taking his medicines, he was generally not a threat to anyone. He wasn't what I would say particularly well, but he was not dangerous. When he stopped taking his medications, of course, then he would often revert back pretty quickly to a fairly frightening or dangerous state. So anything we could do to increase mental health system availability for young people has got to be a win.
What's your final read on this bill? Is this a net good, a net bad, or is it pretty neutral along the way?
I think it is a net good primarily because the Democrats basically got nothing of what they really wanted. I mean, they've been screeching about a lot of these things for years. Assault weapons ban, high-capacity magazine ban, mandatory universal background checks on all firearms transfers. They didn't get any of that stuff in this bill. Republicans are also now in a position to say, well, they wanted a gun control bill, and we passed something that does an awful lot of things that are really important and good. Let's not pretend that we don't care about this. We obviously do care about this very much. We passed the bill.
All right, Clayton, it was good to talk with you. I hope to hear from you again soon.
Okay, great. Thank you.
If you'd like to read more from Clayton Cramer, you can find his website at ClaytonCramer.com.
All right, so my takeaway from this is that we have a Second Amendment activist who is saying there's really nothing to worry about here. It's primarily good things, and the stuff people are freaking out about is primarily neutered. And on the other hand, we have a firearms lawyer who is saying, no, there's actually some serious potential for abuse here.
Yeah. And I'll tell you right now, the one bit from his that has been haunting me is the bit about South Dakota and the federal funding on the how many states that are states that would not normally touch a red flag law would go forward and say, hey, we want that federal money. why don't we go and draft ourselves a red flag law? The good news is, and Clayton Cramer outlined it beautifully, and Benjamin Blatt agrees, no state has any due process law attached to theirs, and such that someone can falsely accuse you, get a punishment, or and many of them get it so that you can't use a public defender if you want to use a lawyer without an expense to yourself to get your firearms back. So there's a chance that a bunch of states will do that. But again, I can't lie. His statement about the judges ganging up on you because all the risk to him is if he lets you keep your guns. So he's got an incentive to not.
It's really discouraging and worrying whenever a flaw like this is pointed out because, well, there's really nothing we can do about it. The big problem here is people. And there's no getting around that. Yeah, there are people who will go to extreme measures in order to not admit fault, even if that means innocent people get punished. And I don't have a good solution for that, and I wish I did, but people suck, and there's no solution. Really, the only other thing I want to point out is I don't know if Sean Sorrentino came up with this or if someone else did and he just popularized it, but I really like the takeaway is that with these red flag laws, what they do is they end up arresting the guns. And if someone is dangerous, you don't arrest the guns, you arrest the dangerous individual. Because as we all know, guns without people behind them are just inanimate objects. Mm-hmm. So, no deep point to that. It was just a case of, I thought that was really relevant and eloquent, and I wanted to get it out into the public consciousness again.
Yeah, and another thing that was out of the public consciousness is the Baker Act, and I think that the Ben Blatt's talk about the Baker Act is absolutely a thing to point out, is that we already have essentially the ultimate red flag law, which does exactly the right thing. Somebody is a danger to themselves. Well, you can make a request and people can come in quickly. They can move quickly and they can grab them and they can put them on a hold. And the person can only stay there for 72 hours max, and then they have to be released and they can go right back home. There's no hearing to maybe you'll get your guns back. No, you have to either go back or go before a judge and actually get committed by the judge. It's not considered a involuntary commitment for the initial Baker Act evaluation. So you don't lose anything. If everything just salts out, all you've lost is the time, which is not a trivial thing. But again, it seems less rife for abuse than red flag laws, however they're written. So that is certainly something to keep in your back pocket to discuss when someone says, oh, we need red flag laws. Well, we actually already have a law that's federal and affects everybody, and I'd even forgotten the name of it. So that's something also we need to get back into the zeitgeist.
See, this is surprising to me because I have known about the Baker Act for decades, and okay, while I didn't think that everyone knew it, I didn't think it was a big secret.
It wasn't a big secret. The moment he said Baker Act, I knew exactly what he was talking about, but just before he said it, it was just nowhere on my radar, is really what I'm saying.
Huh. Okay. For whatever reason, and it may say a lot about me, it's just I've known about it for quite some time. So, as Weer'd said earlier, I was the one who suggested that we bring in a professional to talk about these things, and I recommended Ben Blatt because he's smart and my friend and pro-gun and available. Oh, and free. And so, like I mentioned last week, here we have Benjamin Blatt, Esquire, talking about the legal implications of NYSRPA versus Bruen.
So I'm very pleased to welcome back to the Assorted Calibers podcast, firearms lawyer Benjamin Blatt. And of course, now the one that we've all been wanting to hear. I want to hear your take on the NYSRPA versus Bruen case, and specifically what that means for American gun owners and Americans in general moving forward.
So, in general, Bruen's an excellent decision. There are some pitfalls, which I'll get into, but the short form of it is over a decade ago, we had Heller, which involved a District of Columbia ban essentially on assembled firearms, handguns in the home. You could only keep them locked and unassembled. And Heller found that no, there is a historical right to bear arms for the people, that it's a right of the people, not a militia, not a state right, and therefore people could keep handguns in their homes. McDonald followed that up out of Chicago with some extension, but the key from Heller and McDonald was that the test for the Second Amendment should be what is the text and what is the historical surroundings of that text, if there's any questions as to what the text means. So Bruen is basically the next case in that same line. It takes that same exact standard, the historical and contextual text test, and says we are now applying this in general to the right to bear arms as a concept, not just in terms of keeping them in your home, but in terms of the right to bear arms in general, period. So basically, as applied to the New York case, it's a question of can you have those arms outside your home? And the Supreme Court found that yes, you can, because if you look at when the Second Amendment was brought into fruition in 1791, there were very little weapons restrictions, very little arms restrictions. And those arms restrictions were either rare or related to unusually dangerous and basically unique weapons. Those might have restrictions. Other than that, though, there should be no restrictions. Then they looked at, okay, that's the Second Amendment. But how do these amendments apply to the states? Well, we found that the Second Amendment and the other amendments from the Bill of Rights apply to the states through the 14th Amendment. So that's 1868. So then they looked at the historical context in 1868 and found that, yes, again, still in 1868, firearms laws, arms control in general were very rare, very limited, and should not be given weight to indicate that that was a commonplace thing. So the end determination was that the test for the Second Amendment is not this two-part test that the courts have been using since Heller, where they say, okay, well, is there a good reason for the government to do this, and does it kind of bear up to some historical basis? Basically, the court's applying intermediate scrutiny. But essentially, the Bruen court looked at it and said, no, intermediate scrutiny is clearly wrong because this is in the Constitution. This is a right. Second of all, normally we would say strict scrutiny, but we are not going to even say strict scrutiny because we have said previously that this is a question of what does the plain English of this text say. It is not a complicated amendment. So they've created a test that is even more strict than strict scrutiny, so to speak, that smashes all of the prior court determinations of these two-part intermediate scrutiny tests. And the end result of that is that you have to look at all of the arms restrictions in the United States, all of these state laws, all of these federal laws that say that they're going to prohibit firearms, and ask, would these still hold up to the current standard? And that's important, and that's a good thing, because we have states like Delaware that recently passed an assault weapon ban. We have states like New York and New Jersey that are pushing restrictive firearm bans right now, pushing body armor bans. But they all would have to then be tested against this very basic, what does the text of the Second Amendment say, and what is the historical context? And none of those bans that would really hold up, which is good. It means that they're ultimately going to fail when more lawsuits are filed. For example, New York is proposing a ban that would say, well, the Supreme Court said sensitive places are an okay place to regulate guns. So we're going to define sensitive places to mean any mile in New York City or New York in general with a population density of more than, I think it was 10,000 they were shooting for. Mm-hmm. That's a sensitive place. Now, their idea is that they're going to defend this in federal court by saying, well, Bruen says that we can regulate sensitive places. But that's not what Bruen says. What Bruen says is that sensitive places such as government buildings, schools, those were recognized as being places you would generally regulate firearms in 1868 and 1791. A city street, regardless of the population density, does not automatically become a sensitive place just because someone in the state government said it should be. Body armor does not automatically become an unusual or deadly or specifically very dangerous weapon just because someone in the state found it should be. If anything, body armor is obviously not such a thing. Moreover, because every cop in the United States wears it, it's definitely a commonplace arm. So these are things where these states are trying to get around the decision, which is going to result in a whole bunch of lawsuits or amended lawsuits that hopefully will be successful. But, the question we're going to have is the court going to actually start enforcing Bruen immediately, or are we going to have a decade off like they did after Heller, where the Supreme Court basically just ignored all these gun cases and these splits in the various circuits? Because a lot of these laws, for instance, are coming out of California and Washington in the Ninth Circuit. You and I both know the Ninth Circuit is going to uphold all of these arms bans, like Washington State's magazine ban coming into play in a couple of days. But under Bruen, that magazine ban should automatically fail because it's a ban on common arms. So-called high-capacity magazines are the standard for firearms in today's day and age. Therefore, under Bruen, there should be no regulation of them, period. You may regulate that they can't be brought into a government building, but you can't say that people cannot possess them. So I think overall, the Bruen decision is excellent in terms of providing the next bedrock standard for fighting gun control laws across the United States. Now, the downside is Justice Thomas's repeated references to acceptable regulation of unusual or especially dangerous weapons, which is basically not so veiled code for we are not going to approach repealing the NFA anytime soon.
So I agree with you on that. And that was also referenced in the Heller decision as well, essentially them staying the heck away from the NFA, which I disagree with, but I can understand not wanting to tackle something as large and as established as that. But do you see some twistings of that coded word to mean other arms or various ideas?
Oh, certainly. People are going to attempt it. I would turn around and argue that based on the decision from Bruen that the Second Amendment protects the possession of common arms of the day, based on that alone, that body armor should be unregulated, period. That short-barreled rifles and short-barreled shotguns, being only differentiated by barrel length from normal rifles and normal shotguns, should be immediately taken out of the NFA. That the only machine guns that should remain in the NFA are historical pieces. That auto sears, anything involving an M4 or AR-15 style or an FNFAL, those are common arms in semi-auto today. And it is common to find them full auto among police agencies in the military, even if they're not going to repeal the NFA, that those would have to be unregulated because they are common arms. But I don't think that they're going to go that far. I think there's questions as to whether or not they will uphold some of these laws being passed, like the so-called assault weapons ban in Delaware. One of the things these states are going to do is basically say, well, we prohibit these firearms. They're not allowed in the state. Therefore, they're not common in the state. Like, for instance, California's gun list. They've got that list of acceptable guns in California. If your gun is not on there, you either can't have it or it's going to be very uncommon in the state. So I could see California saying, well, since the gun's not on our list, it's uncommon here, we can regulate it. But that's one of those, logical circles where they're basically claiming they can regulate something in violation of Bruen because they regulate something in violation of Bruen. Mm-hmm. The downside is, in terms of defending Bruen, is that unless the NFA is repealed, they have something to fall back on to say that we justify this because the federal government already does this. And that's the 1986 Hughes Amendment to the NFA. Because the only reason that I would not be able to argue today is that machine guns are truly common arms is that they have not been available in new production to be commonly available in over 30 years. So basically, for instance, the reason that machine guns could be regulated is that they're not common. The reason they're not common is because they're regulated. Mm-hmm. And since that probably would actually hold up as far as federal law goes, I could see states relying on that same principle to argue that their local bans should also hold.
You could also argue that the NFA in its inception was extremely chilling given the value of $200 for a tax stamp, back then.
Oh,
so
absolutely. And there are language about surety laws, that some of these states requiring insurance to possess firearms. I think Thomas's language about those being improper laws would affect that. But unfortunately, the only references Thomas made to Miller in his decision were in relation to there being some firearms that can be regulated. Unfortunately, since the Miller decision, the Supreme Court has consistently ignored the parts about how common firearms in use by the military should not be regulated by the NFA, which was the actual decision in Miller, to rely instead on the other part of the Miller decision, which is that as long as it's for tax purposes, you can regulate firearms. So the Supreme Court continues to rely on the firearms can be regulated if for tax purposes or, in this case, unusual or dangerous. But they ignore the other part of the Miller decision, which was if it's a common military firearm, it's not supposed to be under the NFA in the first place.
And never mind the fact that Miller was in possession of a short-barreled shotgun, and that was the question that he was that he was holding, that it should be protected under his Second Amendment rights. And the very first military arms were what would be considered short-barreled shotguns.
Well, the Miller decision in and of itself, the way it came out, other than, Miller having died before the Supreme Court making the decision, him having no lawyer to argue before the Supreme Court, so they took the government argument at face value. But one of the things that was built into that was that the two of the judges on the court at the time were military veterans. And they both said, we're military veterans. We know what arms were in use by the military when we were in, but we recuse our personal knowledge. So they knew that shotguns had been used and were being used by the military, because this was right after World War I, and shotguns were huge in trench warfare by the U.S. military, specifically cut downs. And they looked at that and they said, okay, well, we're going to ignore that knowledge, and we're going to find that the Miller has failed to show that a shotgun is a common military arm. Therefore, because he failed to show it's a common military arm, it's properly regulated by the NFA. But the flip side is that part of the decision alone, had anyone been thinking in those litigation terms back then, should have resulted in immediate lawsuits for people saying, well, then why does my BAR have a tax stamp? It's current use by the U.S. military. Why does my Browning machine gun have a tax stamp? It's current use by the U.S. military. But that did not happen. And at the end of the day, these decisions, as we have found out from this past week with Bruen and with the Dobbs decision, Supreme Court decisions only have the weight that the current court gives them. And since the Miller decision, the courts have decided pretty much unanimously that the only references Miller should have is to the precedent that you can regulate firearms, not that they should only be regulated in the NFA if they're not common military arms. So as much as that was the actual decision in Miller, it's effectively dead law. And because of that, and because Thomas was not willing to even really approach that subject and pretty much signaled that repeatedly in his decision, the end result is going to be that the NFA remains untouched, despite there being multiple common arms still subject to the NFA. And I think that there are going to be states referring specifically to the NFA and to the Hughes Amendment as justification for their regulations, because it's established federal precedents, essentially.
Well, as I like to say, we didn't lose our Second Amendment rights that we have lost overnight, and we're not going to get them back overnight. But I think overall, we gained a lot back with this NYSRPA decision. Oh, yeah.
I mean, the bare basics that we got back were the actual basics of the decision were you cannot have a special justification section to your firearm permitting. You can establish a firearm permitting scheme or a firearm license scheme that has a uniform application and that relies on basic, reasonable purposes, such as run a background check. The court all came out and said that the existing shell issue states were fine because that's what the shell issue states did. Although many of those shell issues still have training requirements that the court really should have looked at and said, this is not uniform and it's a burden, but they didn't. And they also didn't address the issue of many of those states requiring you to get separate special permits to purchase a firearm, which is an additional burden. But they basically said the concept of shell issue is fine. The concept of may issue is not fine because may issue relies too much on standards that are not uniform. So that's 6 states in the District of Columbia that have to change their language. And those are the states that are mostly pushing back on the idea that, okay, well, we're just going to act new gun laws to get around Bruen. And part of that is they're ignoring the whole shell issue, may issue thing by saying, well, we're going to say it's shell issue, but only shall issue if you live in certain geographical regions, which we're going to narrowly define, which is no better. As was pointed out in an article the other day, Hawaii, over the past several decades, has issued exactly 4 firearms permits under their may issue standard. And they do not plan to really change that, even though they're now required to go shall issue. They don't want to change that because Hawaii has its own issues with allowing people to have firearms, in terms of the whole issue with Hawaii being essentially, despite the fact no one wants to talk to it, an ethnic state.
So I've got one more kind of technical question is, so unless the appeals courts do recognize Bruen, which, as you said, there are some that will not, is the next step to someone who's challenging a specific state's law? I mean, well, honestly speaking, we've even got like New York's law that was directly addressed by the Supreme Court, and New York is saying they're not going to respect the court. Like, what is the recourse, and is there a faster action than just keep going back to Supreme Court and then potentially it being ignored again?
No, unfortunately, there's not. The recourse is just going to be keep suing them, bring it before the Supreme Court, and then you get to the whole thing. It's sad in that they don't recognize the irony of repeating it, but back in World War II, when the Pope condemned Germany, and the response was the Pope has made his decision. Now where is his armies to enforce it? I don't have the exact quote. I'm butchering it, but people are unironically using that same language to refer to the Supreme Court. Like, Thomas has made his decision, but he can't enforce it, so we're going to ignore it. That way lies the corrosive destruction of the rule of law. And the sad thing is that because these are the largest population states in the country, with the exception of Texas, there's going to be a lot of leeway given to them by the circuit courts, which means they're going to be allowed to do this for quite some time before litigation actually brings them to head. I think you're going to see tens of thousands of New Yorkers, if not hundreds of thousands, applying for those carry licenses or carry permits. But I think you're going to see very few getting approved until 5-6 years from now, when it's back in front of the Supreme Court, assuming the Supreme Court is willing to re-examine the case again. Because, New York and New Jersey are looking at the Second Circuit. California and Washington, you're looking at the Ninth Circuit. Those are the 2 circuits most likely to, unfortunately, blow off the Supreme Court and ignore the whole rule of law and constitutional process of the courts in favor of their political ends.
Yeah, I guess also unless Congress actually goes forward and enacts a federal law that also supports the NYSRPA decision, which is possible.
Congress can't really do that.
Oh, yeah?
That's the fun thing. This is a question of what does the Constitution say. Any law Congress makes that would be contrary to Bruen is going to be right on the chopping block in terms of an immediate lawsuit or a follow-up lawsuit as well. The only way to effectively overcome the Bruen decision and the Second Amendment is to have a constitutional convention. And that's never going to happen in this day and age, because the people who want to get rid of the Second Amendment are all too well aware of the risk of actually trying to push forward a constitutional convention. You don't get to narrowly tailor it to, you're going to have one amendment that repeals the second.
Well, I was actually going more towards the line of having actually a pro-gun law that protects the second on a federal level.
Well, what you'll probably actually have happen is about 35 amendments introduced that provide separate and unique rights for everyone's separate identifier subclass, and results in the complete destruction of anything approaching what the Constitution is today. And that's a risk that everyone recognizes, because unfortunately, once you open up an actual constitutional convention, you're looking at, well, what is California going to be pushing? What is New York going to be pushing? What is Texas going to be pushing? We've reached the point where we're these United States, but the political goals and the political means and ends in the center of the country rarely match those on the coasts.
Well, yeah, that's certainly something interesting to look forward. Hopefully there will be some straighten up and fly right, but this may be a declaration of war.
Well, ideally people would look at the cases from last week and say, it's not really about guns. It's not really about abortion. Both of those cases were essentially wins for the Bill of Rights. Bruen was a win for the Second Amendment as written. Dobbs was a win for the 10th Amendment as written. Both of them were 14th Amendment wins. And the religious case, the one that came out the other day, was essentially a win for the First Amendment. It's not about creating some weird special state of being where we're ignoring the Constitution. All of those decisions have in common is that the court looked and said, we are applying what is the text of the Constitution. That's it. No more games. We're not reading stuff into the Constitution that's clearly not there. And that's all it was. All of these have been basically wins for rights of the people. The Second Amendment win is the 14th Amendment applies to the individual people, is a win for our individual rights. The Dobbs decision that followed was a win for the 10th Amendment that basically said, we make no decision on this. It's not in the Constitution. If Congress wanted to pass a law, they could, but you cannot have the courts making the law in place of Congress. Therefore, until that point, it's the states' rights issues. For that decision, not to get super politically controversial, but if Congress wanted to make a law about Dobbs, about abortion, there's nothing in the Constitution that would prohibit them from doing so. And that federal law would control. But for 50-odd years, instead of passing law, instead of Congress doing their job, they've relied on the courts to make law. And it's not supposed to be the Supreme Court's job to make law out of whole cloth. And that's pretty much all that decision said. This was never our job. We're repealing the decision for that. For the Second Amendment, they looked at it and they said, all of these gun control laws, this carry question out of New York, all of them have the same flaw of basically treating the Second Amendment like a second-class right. The rights are all equal. Because they are all equal, we are basically saying, no, this case is a loser for New York. That's it. That's really all that decision said. So from that perspective, the wins last week were all wins for the Constitution. For all the people claim, though, this is an activist court, compare and contrast to genuinely activist courts of the 60s and 70s, where the courts were making up things from whole cloth that weren't in the Constitution, and the Supreme Court was asserting its right to do so and control the federal government and control the states without constitutional grounds, versus last week where the court looked and said, we don't have the authority, or the Constitution doesn't give the states the authority. And because it's not in the Constitution, this is the way we must rule. Because they applied the same standard to all those cases. The same, what is the text, what is the history? That's it.
I mean, those are all great points. And I'd like to thank you for your time. Benjamin Blatt, firearms lawyer.
Thank you for having me again.
I've got to say, it is very, very interesting when we get into these recursive arguments on the Supreme Court has ruled that New York can't do these shenanigans with gun owners, and New York says, no, we're going to keep doing shenanigans. Well, then we'll sue you for doing shenanigans, and maybe it'll make its way back up to the Supreme Court, and the Supreme Court will say, no, you can't do those shenanigans. They don't listen to the Supreme Court. So I mean, it's actually, since the time that Ben and I talked, things have changed quite a bit with the various laws. I've got a bunch of links in the show notes, and we're already going quite long, so I don't know if we really need to go through all over them. But New York is definitely stepping back on continuing to deny permits, even though that was the initial take from everybody, from the Massachusetts AG and New York, and I think California also spoke out saying, no, we're going to keep denying permits. And but Massachusetts has already totally caved. They have set back to, if you are in the state of Massachusetts and you have a permit that has a restriction on it. So if it's a target and hunting only restricted LTC, that is still there until you either get it removed, and I actually don't know where it goes through. I got my restriction removed when I moved to this town, and they couldn't do it, so I just applied for a brand new permit. So I actually had 2 permits for a couple of months. But yeah, so the restrictions stand, and so therefore if you've got a restricted permit, you still can't carry. But if you apply for a permit right now, you will get an unrestricted one per the AG's guidelines. So that's certainly been rolled back. But of course, New York's going through with, they're pushing a new law that's like businesses have to post signs that say that they welcome people who concealed carry. Otherwise, it's a gun-free zone. That's a just a dirty little slippery slope.
I think we all knew that New York, California, and Hawaii would dig their heels in and fight this.
Mm-hmm.
But, well, we didn't. Well, okay, I'm sure NYSRPA, did it to defeat New York. But for the rest of us, we didn't expect an overnight victory. As you said, we didn't lose our rights overnight, and so we're not going to get them all back overnight. But absent those big three, the others are caving in.
Mm-hmm.
I'm not really sure about New Jersey. I've heard some alternating things, but, well, when Massachusetts caves in, that's good. And not only is that an immediate victory, but it also makes it a lot harder for the holdouts to win. So that's good. I am highly confident that when there's another lawsuit challenging California or Hawaii or New York, that it will win. It's just a matter of, well, first someone has to prove standing, and they've got to bring the suit, and it's got to wend its way through the courts, and who knows how long it's got to appeal upwards. And time and expense are their own kind of obstacles. So I don't think it will be anytime soon. But in general, I would say that, the first pound of the stake into the vampire's heart has been done, and it's hissing and it's clawing. It's not re-dead yet, but at the same time, it's not attacking us either. And so it's just a matter of, all right, stay the course and keep hammering, and eventually we will kill this thing.
And I am very, very pleased to see that the pieces are moving on the board. So while this lawsuit is going to beget more lawsuits moving forward, we're not fighting the same battle over and over again, and we are moving the ball down the field. And again,
we get to fight exciting new battles.
Exactly. And so we are heading in the direction. And this is exactly the action that the anti-gunners are doing. And they don't go for everything. Oh, let's ban all the guns. Though we know they want to ban literally all the guns, unless you have some special permit that's granted to you by the president himself or whatever, because you're rich and powerful. No, you don't get to have any guns at all, is exactly how the anti-gunners want this to go. But they can't get that overall. That's why they went for the assault weapons ban. Very, very few people had AR-15s and AKs. They were somewhat rare, and the ARs at the time were extremely expensive. And so they just said, yeah, no, we're not going to, we'll just go after these. They look like military weapons. They scare people, and not a lot of people are using them. And that was a successful tactic. And that's exactly the direction we need to go. So long as we're going in the right direction, we're going through. And for everything that we said about the Bipartisan Act, it's not the greatest bill in the world, but you know what? We could be going in the right direction with that. The money for schools and mental health stuff, that helps everybody. And that's, it's not Second Amendment focused, but that's the right direction. And NYSRPA is a solid win. And the next fight's going to go through. And the courts have sent a whole bunch of 2A decisions back to their respective appeals courts for review, pending Clarence Thomas's massive spanking of the anti-gunners. And that will be another thing interesting to watch, and we will be reporting that on future episodes of the Assorted Calibers podcast. But again, this is nothing but good news for us. And so on that note, I want to thank each and every one of our listeners, and a very special thanks to all our supporters on Patreon. To become a Patreon patron, go to patreon.com/Assorted Calibers podcast to sign up. Patrons get an early release of podcasts, plus bonus content like the hilarious blooper reels, the ACP film tracks, and the ACP mag dump. And may I mention that for Independence Day, I decided, you know what, let's throw a little gift out to the people. We did a film track a little while back of Iron Eagle, and I thought that would be an exceptionally fun Independence Day film to go through. It's American, and also, let's be honest, everyone's talking about Top Gun and Top Gun Maverick. So you know what? Let's throw in also the Iron Eagle, which at the time of us listening to, I was unaware predated Top Gun.
Yeah, but not by much.
Not by much.
If my hazy memories are correct, it's like one was a spring movie, or maybe early summer, and the other one was like late summer, early fall.
Yeah, it's like 3 to 6 months.
Yeah, I remember being in the theaters to watch Iron Eagle, and the preview for Top Gun came up, and it was like, oh, hey, that's another movie I want to see. Oh, right, I should say something else here.
I love Weer'd.
It's like, Weer'd is quiet. There's something wrong. What's going on? Oh, right.
It's your turn, dear.
Also, please remember to rate us on Apple Podcasts, subscribe to us on the platform of your choice, and share the show with your friends, both online and off.
I got a blog. It's called Weir'dWorld.com, and you can also hear me on Handgun Radio on the Firearms Radio Network.
And I have a lot of irons in the fire, and you can find them all by going to Linktree/Erin Paulette.
And that's pal at, like, she's your little pal. That's the lesson that we've learned. And thanks to Nate Spencer for our music.
Well, I live in mostly free America, and up until recently, Weer'd didn't. And, well, it may not be as free as Florida, but it's a lot better now. So...
our freedoms are still assorted, and so is our
podcast.
podcast.
That's fair. Good night, everybody.
Good night.